Cameras are off, microphones are off by standard, but we'll have an opportunity later to do some Q&A. We'll bring you all on board. Okay. Now, by my time, we are ready to go. I'd like to thank all of you for joining us today. We've got people from all over the province and then some. My name is Troy DeSouza. I'm a municipal lawyer, litigator, prosecutor, and I've been in this practice for over 28 years. Hence, you see my extra pair of glasses on the top. It's just one of the consequences of having to do too much reading of the law. Okay, hopefully you don't have to deal with that like we do sometimes. We're going to speak about how best to give oral testimony in court. That's why it's called 10 Things the Judges, Hate About You. And we want to get them to like you because it impacts your case, our case. And this actually came about by one of our local government clients who had a trial where one of the judges was not as enamored with our professional staff witness as they should have been. And so we wanted to look at how can we improve this giving of oral testimony for everybody. And so this is why it's being shared to as many people as we can, and it's at no charge. It's also the kickoff for GovLaw and the Regulators webinar series, which we do at the last Thursday of every month starting in September. So we'll have our first webinar on case law update on September 25th, Thursday, 12 to 1, same time, and we'll continue on from there. So we do encourage you to join us for that one as well. And I do want to thank, from our part at the Regulators and the firm, both Sam Malone, who's articling with us, and Alex Volchek, who's one of our legal assistants, for putting together this presentation mostly. And both of them, you'll find that with Alex, some really incredibly improved graphics that we use to help educate and have a better interface for our PowerPoints. And Sam has an engineering degree, one of the few people who are going through law with that background. And so for some of you clients who have some complex building and zoning matters, come our way. We got engineers. Okay. So thank you again for joining us. 10 things the judges hate about you, and away we go. So what we're going to discuss in this next 40 minutes, because I do want to focus some time for 20 minutes of Q&A, war stories, whatever you call it. We'll talk about the Broadway show trial, which is what a trial really is, the best evidence rule, case law insights, so you can see what some judges actually think about witnesses. And we'll get into the meat and potatoes, which is the top 10 effective testimony tips. Now, the webinar is scheduled to end at 1 p.m. And I will still be sticking around after. I know some of you may have to go. That's totally cool. Peace out. But if anyone has some more questions and thoughts and answers, we'll continue on for at least another 10, 15 minutes as permitted. And the other thing I will let you know is the webinar is being recorded. And so if you didn't catch all, if you think someone else could utilize this benefit, it will be on the Regulators website after this for free. And my suggestion is that if you are going to give testimony, or if you have a layperson witness going to give testimony, or if frankly you're prosecuting a ticket, take a look at this webinar as a refresher, and it'll help you prep and get better up to speed for your case. So let's talk about the Broadway show trial. A trial is basically a show. It's part of putting on what you've been working on for the last 2 years, maybe longer, maybe 6 months, but it's all got to be distilled into this one little bit of a performance, and you've got to make it work and count. Okay. A trial is essentially um, like an iceberg. We're just having a little bit that we do in court. Sometimes it can be even smaller than you think, but all this stuff, 90% of that is underneath. And so, what you need to do is to make sure that at the trial, you were able to close the deal. You were able to stick the landing. And I've seen too many cases where you've done a lot of prep work and everything's all good, but it gets flubbed up at the trial. So that's the goal here. We are focusing on the 10% of that iceberg. We there's other things we can talk about, how to prep and how to get to court and all that. All good stuff. But this is the 10%. And everything that matters is in this show trial. So one of those things that we talk about is evidence. Evidence is critical to a trial, and ultimately, a trial has two key components, just like a Broadway show. You got number one, witnesses, also known as actors, and number two, you have evidence, also known as the story, right? So if you look at the Broadway show, actors and a story make for a good show. And as you know from watching a lot of stuff, whether it's Broadway or movies or TV, actors make a difference. The story makes a difference. Guess what? The trial is going to make a difference. So this is where we're trying to focus on. So when we come to evidence, we are looking at an array of things that are relevant for the trial, right? We can have photos, warning tickets, letters, witness statements, perhaps oral testimony, audio, video, maps. I mean, there's a whole bunch of things that we can put in there, past orders, very relevant, medical. Now, not all of these will apply. I'll give you an example. So, witness statements, we don't actually submit them in as evidence. That's meant to be people testifying, right? But the oral testimony is people actually testifying. So not everything goes in, but there's a lot of stuff that's there that's good, and you want to use the best evidence you can. And how do you know that? Well, you start with this notion it's got to be persuasive. Is it going to be helpful? So you look at your witnesses and your evidence. Is it persuasive? You look at supportive documentation. So if a witness has said something, can it be supported with a photo or with a letter? All of these things help your case. And then ultimately, this is the most important part. Does it meet the elements of your offense, right? We've got bylaws. We've got key elements. We've drilled this down in courses like Prosecute This, which many of you have taken, and we need to prove our case in court. And so those elements of the bylaw, the key elements we need to prove in court, and generally, we want to make sure that they are in fact proven in court. So does it meet those elements? And if it works, good. We are off to the races. So let's look at case law and some insight just to give you a sense as to what works, what doesn't work, and what's abysmal. And these are cases actually that Sam's helped put together from actual cases, quotes from judges, so you can get a flavor as to their thinking. And I can maybe explain a little bit as well, give you a bit more background on it. So, a good witness. Well, good witness is in this case, the judge says I was impressed by and gave evidence in a clear, concise manner. She readily acknowledged the limitations of her role. In this case, this was an expert witness that took the stand, and they had to comment on a report of the plaintiff's expert. So it's an expert commenting on another expert. And you can always see where that could get into very competitive, argumentative situations. And the judge also had remarked in this uh, accident expert case that the witness was impartial, confined her evidence to the science of her discipline and profession. So, a witness, helpful to the judge. And remember, um, in a trial, in most of our trials, certainly for local governments, the show trial has an audience of one. That's the judge. So that is the person that we are trying to impress and convince and persuade to give us the order or the relief we seek. A bad witness, okay, court says, well, a little bit high on herself, opinion of herself, and showed a lack of familiarity with the role. And her evidence was surprising, concerned in terms of the breadth and the breadth of the comments. So in that case, again, a plaintiff was involved in three car crashes in 5 years, and the witness was retained to rebuff another report. But rather than assisting the court as an objective expert, what happened was the witness became an advocate for the complainant, the plaintiff, and that undermines the objective expertise that is needed when a court's looking at that type of role. Okay, and so some of the things that was in the decision was that the uh, witness attempted to enhance their credentials by claiming superiority over the other witnesses and refused to adjust when there's contradictory evidence. So something that's important there, like you got to be able to read the room a little bit. So if different pieces of evidence are coming at you, you've got to adjust. And I had a case for a local government some years ago where I had a witness from the SPCA saying this is how they followed a process on a dangerous dog matter, and it was pretty clear by the evidence that action should have been taken earlier. This incident, this attack or whatever had happened, could have been prevented had a different approach been taken earlier. It was pretty clear. But the officer refused to adjust and bend and just say, yeah, I guess I should have done something. I guess I should have taken that action, but they just kept hiding behind protocols and procedures and stuff, and it ultimately undermined the officer's testimony and then limited us on some relief that we got. So we got generally the relief we wanted, but we could have gotten more, but we didn't because the officer was focused on making themselves look good at the expense of the case. So that's not what we call a good witness. That's a bad witness. So got to keep those sort of issues in mind as we're giving testimony. And by the way, Sam is monitoring the chat, so feel free to throw some questions. We'll come back to those at the end, and we'll answer all your questions as soon as we get this done. So let's look at an ugly witness. Ultimately, credibility is important, and if you have no credibility, you lose, right? Like if that's a key point. Um, and sometimes the court will even call you a liar, right? In this case, Sykes established herself as a liar, and I give her testimony no weight, as I believe none of it, nor could it reasonably be true, right? So you don't want to be in that situation. Certainly as professional staff, I don't think I've ever had anyone in that situation, which is great. But sometimes the subtleties of credibility can be impactful upon you. Okay. Once had a case where uh, the court said that one of our officers was a little too officious. Now, this is early in my career, and I had to open up a dictionary to know what officious means. I thought that was a good thing. I thought it was like efficient, but it's not. It's a little too efficient, almost to the point of like we got an axe to grind or something. So while the judge had to grant a conviction based on the evidence we put forth, the judge slammed us in terms of the sentencing on the relief and gave us the very high amount of $1. Okay. It doesn't get, you can't get lower than that. So $1 because we're too officious. So how we present, right, is important. So one of the things I'd recommend and suggest to you is that we as local government, as professional staff, if we're in court, whether you're giving testimony as a witness or whether you're prosecuting a ticket, always look and give the perception that you're here as the last resort. You don't want to be here, but you're forced to be here in order to simply do what we call compliance. We're trying to follow the law. So, last resort, let's not look like we're eager to convict or get someone out and mess up with their day. We're just trying to follow the law. And that's the best sort of sweet spot in terms of how you can be a good, credible, positive witness for your case. So let us get to the meat and potatoes of what we want to get into, which is how to improve your presence, your testimony in court. What are the tips? What are the secrets? How do we utilize and advance our best case for the show trial that we are going to do? Okay. So let's start with, and you know, and some of you know me, I like to always go top 10 list like Dave Letterman and start for 10 and go down. Not that they're in any specific priority, but just to pretend I'm Dave Letterman. That's it. So talk not like Yoda, you shall. Hmm? That's the best I'll do for Yoda. Now, my staff knows I like Star Wars, but this is their attempt to troll me to throw Star Wars and Yoda under the bus so you don't do like Yoda. It's true. Do not speak like Yoda at trial. Yoda speaks in a weird, passively like voice, and that's not how we want to speak in trial. You've heard of that saying, there's no I in team. Well, in this case, you're allowed to use I. Okay, and so you want to talk like I did this, I did that, I took action. Like, and so that the testimony is coming from you directly as the first person, and it's an action oriented thing, right? That's makes it easier to follow, and that's exactly where you want to be in terms of speaking to court. Passive language puts people to sleep. Okay, so enough Star Wars trolling, Sam and Alex. No more of that. I don't want that anymore. Positive Star Wars stuff only. And SpongeBob. Okay, speak up. So one of the things that we'll find a lot of people do in court is they don't speak up. And by meaning up, I don't mean loud. I don't want you shouting and speaking like that in court. Just speak in a language and in a volume that the judge can hear you, that the witnesses can hear you, that the other side can hear you, and remember that you are being recorded. There's a microphone in the courtroom, so everyone's being recorded because at the end of the day, there are transcripts we can get, and primarily they're for appeal purposes, right? And so it's being recorded. So sometimes the judge will ask you to speak up. That means also don't mumble it. Speak up, but not too loudly and definitely not quietly. Low talkers are not wanted in court. This is a big pet peeve of mine, speaking too quickly. And it's not just my pet peeve, it's the judge's pet peeve too. So you got the Gilmore Girls. I'm not sure if you've seen the show. I've I must admit I've seen the show, but mostly because I used to live with women. Now I'm an empty nester. Now my girls have gone away. But they speak really fast in that show. And whether it's the Gilmore Girls or it's whether like West Wing or some other TV show, everyone's speaking really fast and it's part of the style, or a Quentin Tarantino movie, that's not how you speak in court. And the reason is that judges are writing down what you're saying. So while it's being recorded, judges can't get the recording because there's a cost to that, right? They can sometimes get it, but have to have it budgeted. but most of the time they're writing or they're typing in their computer. So in order for them to do that, they have to both listen to you and type or write. And so the quicker you speak, they're going to lose it. And so the best way to avoid uh, speaking too quickly is to, as you give the testimony, look at the judge. If the judge is writing away too quickly and is, it's got said that you need to just break, you need to pause, and you need to slow down your pace. Now, hopefully, if you're running the show, then you're in charge of making sure that the pace is slowed down. But if you got a lawyer or someone else there, you're watching back, looking at witness, make note that they have to slow down. I also don't like it when lawyers speak too quickly. So in presentations, right? Because the quicker we talk, and you can just see this, if I'm talking so fast, I'm going so fast, people have tough time keeping notes. But if I start to go a little slower, they can understand me better, right? Less is more. And I appreciate people are a little nervous. And when you're nervous, sometimes in trial, you tend to speak fast. But do like Sergeant Major Morals told me in my basic training in the Army years ago, when you're nervous, walk in like you own the bleeping place. Okay? No, not really. It's the judge's owning, but be confident. It'll be fine. Okay? Okay, this is good. This is I call this my Troy DeSouza patented technique. Years ago, when I actually had time to do things like more research and things, I was looking at how best to give testimony in court, and I looked at a bunch of different things, and it came down to about three key points as you're speaking, was really good from a number of different reasons why. And the first is it's one, two, three. I got it in here. So when you're giving your answers, and again, direct all your answers to the judge, right? So you're in a courtroom. There's another side, another person there, perhaps someone that doesn't like you or is opposed to you or whatever, the defense or this. And there's your side, perhaps you have a lawyer and you're on the stand. You're going to receive that question from either your lawyer or the defense counsel or the disputant, and you should not talk to that person. That's not who you're engaging with. You basically direct your answer to the judge. So you should turn your head and answer the judge. Turn your head and answer the. So you physically answer the judge. And before you answer, you take these three steps. You pause, you think about your answer, and then you turn and speak to the judge, right? You can actually do that in various orders, but you definitely need to pause. Okay. And what the pausing does, it's really important. It allows your brain to better formulate an answer as it comes out your mouth. You can see the image here. You connect the brain to the mouth. If we start talking first, I guarantee you the answer you're going to give is not as good as if you pause. It's like a moment of reflection, and it actually looks like that too in court. So it's not like blah 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 blah. Let's get something out. It's hmm, okay. So judge, this is what I think. And then you give your answer. That pausing is critical to improving your answer. Just there's something about the pause that makes the brain and the mouth work better to give a better result, a better verbiage to the court. Okay, and again, speak to the judge. That's the only person in the room. That is the audience. So you want to follow this technique as you're giving testimony. Probably one of the most important and effective tips I give to all our witnesses. And that's what you should give to your witnesses too. If you've got a person um, going to take the stand. And by the way, like I said, this will be free. So feel free to direct them and send them the link, and they can watch the video themselves as part of their witness preparation. So Number six, answer objectively. This is a really important one for you, the professional staff. Um, you're not the complainant. You're not an advocate even for the complainant, right? You're there in an objective, impartial, professional job to enforce the law, whatever that law may be, whether it's the statute, the regulations, the bylaws. You're just there to get compliance. So it's good if your testimony doesn't take the complainant side in any significant, oh, yes, I could see that being so horrible and bothered. And so I was so sympathetic with that. Like, you're going to start lose credibility, right? Um, Guide yourself with the law and with the elements to the offense. That will help guide you. Oh, what are the principles we need here? Okay, yeah. So, we did have a noise disturbance, and this is the log that this witness gave, and based on that, based on our bylaws, we thought it was important to advance that and get compliance. That kind of testimony, rather than, yeah, that noise is brutal, it's crazy, it should be shut down. Um, don't answer the goal for the judge. The judge will determine what the answers are. You're professional, so you want to have a little more dispassion and objectivity in your testimony. Use the best evidence. So in that previous slide, we had all those different types of evidence to use. Um, Use it, different aspects of that, a whole bunch as necessary. Make sure it's clear, objective, persuasive, and it's supportable perhaps with other witnesses, and then ultimately that it meets the elements of the offense. Okay, so use the best evidence that you have. Number four, answer the question. This is a good one, particularly when you're getting the question from a judge, right? I mean, it's one thing you're on the stand, someone is asking you questions, they're going to try to badger you a little bit. Well, what about this? Again, you should be sufficiently prepped to ground yourself within the bylaw and the law and not take the bait on anything inflammatory like, why are you always persistently harassing us? That kind of thing. But when a judge asks you a question, don't be evasive. Don't be too smart by a half. Just remember the judge is trying to get to the facts and the law as well. So stay on focus on the topic. Be truthful, be accurate, and be objective. Those are probably the three key words I'd say there when you're giving testimony: truthful, accurate, objective, because you're going to be, as the professional staff, that's your higher standard they hold you up to than a typical lay witness, right? Lay witnesses can get away with a lot of things, you less so. Okay, so and it is okay to say things like I don't know or I can't recall. You don't want to speculate on things, but there's a limit to your knowledge. So, like one of the previous examples we showed in a case where the judge says, well, they understood the limits of their testimony. Understand your limits too. Don't go beyond it. It's interesting too because in local government world, we are experts on a variety of things because by the nature of our job, right? Whether it's in land use, zoning, building, you name it, we have the expertise, but we can't come off too much like we've got all those answers. We can just stick close to what our subject matter knowledge is. And if we really need a real expert, we'll have to get one. But for the most part, um, answer the best we can. Number three, what do LGA, BOV, and ACO mean to the average person? Not a damn thing, right? So let's use language that's explainable. Let's not get caught in the bureaucratic jargon because we have a lot in local government world. And if we're going to use an acronym like that, we got to explain it first. So it's like, yeah, so under the Local Government Act, which we also call LGA, boom, that that leads you to that. Or, um, you know, the animal control officer, also known as an ACO, is doing this, right? Well, we've got the context. So, oh, if they're going to seek to change the use on this property, they'll have to go to the Board of Variance, and oh, BOV, boom, we got that. So, all of that will work, and the acronyms are can be made to work for you, right? The only acronym I know is like Run DMC. It was a rap group that was instrumental working with Aerosmith to have the great first rap hybrid rock song. Okay. So let's make it explanatory. Let's make it work for people. Number two, admit errors or mistakes. Now, we are not perfect, and we often have uh, imperfections showing up in some of our procedures and practices. And as long as they don't go to the roots and the merits of what we're trying to accomplish, it'll be fine. It'll be totally, totally fine. And it also shows that local government is still a human institution, just like and just like uh, with regular humans, we do err from time to time. So hopefully with some legal advice, you'll know the errors that you can make that are passable and errors that could undermine the case. So having that distinction before you, that's part of the 90% I'm not talking about, but you'll have that set up. So when you get to the trial, there are some things that we can actually concede. And then it makes you look more professional. It makes you look more objective, and it makes you look like you're actually trying to do the right thing, right? It adds to your credibility. So those are all good. And remember, while one of the earlier tips was like speak in an active language, you remember I said, I did this, I did that, all good. In this one, remember you're still part of the team, and we don't care about you looking good. We care about the case, and do not undermine the case for the benefit of making yourself look good. So in Pulp Fiction, Bruce Willis should have thrown the fight like he was told to, right? I mean, obviously, it makes for a much better movie that he didn't throw the fight. But that's the point of that. Don't let pride mess with you. Okie doke. Let's go to the number one thing. And this is one of the important ones too, is that in a Broadway show, less so a movie, because Broadway shows are live, right? This is why I use the Broadway example, not a movie as much. Um, Sometimes things go to shit, right? It just happens, and or things will go sideways. Things will happen that you the least expect, or like you're gonna get surprised. Those things happen. So maintain the three C's, which I've patented, and I know that the um, I don't really patent it. I've just used it before anyway. But Justice Institute copied me, and I've given them permission to use my three C's: calm, cool, collected. Right? How you present in a Broadway show. If you know, see some of these actors, I mean, things go wrong all the time. They know the inside baseball of when they've done something wrong, but the audience doesn't necessarily know it, right? So, just to as with a judge, you want to keep your cool, and you do it for these reasons, right? Not everything gets noticed at trial, number one. So if you're calm and cool and collected, it's not going to get noticed. And also the judge may not see that, even if it is noticed, as important enough or relevant enough to affect the case, right? So calm, cool, and collected, is a great way to just carry yourself in the trial. And the opposite of that is if you get flushed or flustered, it draws attention to it. So you don't want to have it draw attention to yourself. Okay. So that is uh, probably one of the most important points I'd recommend. And one of the examples I can give you in our trials that we've done, and this is for RDN, actually, we did it years ago, the famous Elaine Cameron Buddhist monk case, is that we had a trial, and for some legal technical reason, there was a mistrial. So it was a year between when we had to go back to court for the second trial. And in that year, Miss Cameron emailed to one of our lawyers um, an email she had sent to her former advocate in the previous trial. Sorry, the advocate had sent to her, right? And in that email was like, Elaine, let's just say it started with Elaine, you are a crazy SOB. Like, and it went down from there, right? And it was all about her ability to in addition to being a responsible dog owner, which she wasn't, it was also it just had personal characteristics of their irresponsibility, mental craziness issues, all in this one beautiful paragraph of an email. And Miss Cameron had sent that to us, and we were like, "That's so weird." I said, "Well, let's just hold on to it and see what comes of it, what may." And then we get to the trial, and we're surprised to see that she has that previous advocate who's not a lawyer, but was a former constabulary or something in England. So she had some experience, and she had her testify, and she had her testify to what a great dog owner she is and how good she is and all that stuff. And I had this little piece of evidence, and I remember before I started my cross examination, I turned around to the witnesses, to the people watching a trial, which was basically half of the RDN staff, including Tom Armet, and I gave them a wink because I knew they knew what was going to come. And you shouldn't wink in court, by the way. And thankfully, my head was turned that way, so the judge didn't see it. Um, but I started to ask her questions like, "Are you a responsible dog owner? Are you, this? Are you that?" And I topped it with, "Are you mentally sane?" Right? Because these are all things that were in the thing. And then I asked her to read that. And you could just see the walls of the matrix lines falling down. It's like totally thing. And then it was flustered and it was a gong show. And they lost their case largely because of that piece of evidence from their own side. So um, you keep cool. Keeping cool is good when things go sideways. And if you're not prepared for that, um, it's gonna cost you. So those are the top 10 tips. And at this stage, I'm going to open it up a little bit to some Q&A. We could share some experiences. Uh, and if anyone has any questions, oh, look at that. Perfect timing, 12:40. Sam, I told you I'd be on time. So I'm looking at the chat there too. Sam, you can pop your head open and let me know. Do you have some questions already, or? I see a lot of this stuff here.
Hi, everyone.
Uh,
I'm Kismet Bandor. I'm a partner here at GovLaw, and while the questions are being collected, one of the things I might want to just point out to you is that the microphone that's in front of you, it is only for recording. Some people think it's for amplifying. It isn't. So when Troy's recommendation is that you speak up, uh, the microphone in front of you doesn't amplify.
okay. So we can, yeah, just open it up here and see if there's any questions. And let's just see what else we got here. Yeah, and actually, while I'm also here, I'll just make sure I'll put on the next slide so you know that there's another. Our next webinar is actually going to be on Thursday, September 25th and we encourage you to join us for that. There'll be a notice coming out for that perhaps tomorrow or something. And then we start our regular webinar series on a lot more substantive things. So it's case law update, but funner. And we've got an array of cases to share with you that you might find very, very interesting. Um, and by the way, if you can, are they able to speak if you turn your microphone off, or I wasn't sure about that.
Yeah, my understanding is that you can just turn your camera and microphone on and just like I've just done and can start speaking. Or if you want to put the question into the chat, we can also then read it out loud and answer that as well. Um,
Sounds good. Yeah, lots of people here. Don't be too shy. And let me just see if there's anything else here on there. Yeah.
Okay, there is a question that's just come in. The prosecution of municipal tickets information is held in provincial court or traffic court? Is a question from Colin Ash.
Yeah, it's a good question. And if you're doing your own prosecutions, which we strongly encourage you to do, it is going to be in provincial court. And traffic court is part of provincial court. So it's all at lower court level. And it could be heard by a judicial justice of the peace or a provincial court judge, depending on what sort of priority they're dealing with. And if it's in traffic court, because they'll conglomerate it with a bunch of other things, it will likely be a judicial justice of the peace, also known as the JJP, right? So, and again, if some of you've taken prosecute this, which teaches you how to prosecute tickets in court and all that, it the presentation of how you appear and what we've talked about, these top 10 things here, are something to still take home with you in that presentation. So yes, you got witnesses. Yes, you got to manage your witnesses, but you also have to manage yourself. So when you're running a prosecution, it's important to remember that you will give testimony, of course, but you're also in charge of other people's testimony. So you're both a prosecutor, witness at the same time. You're running the show. So you're like the director and you're the actor in this Broadway show trial. We got one here from Deb Wood. Can we speak on disclosure, timelines for disclosure, standard 30 days before the court date? Yeah, good question, Deb. If we're dealing with a hearing, and it depends what it is, if you're in uh, the BC Supreme Court, you're going to have lawyers, so there are rules and deadlines on disclosure and stuff, so you don't have to worry about that. But when we get to provincial court, which is mostly where you're going to be at, you are going to be um, wanting to give disclosure at the earliest opportunity so that it can get set for a hearing date. So there's no specific date or deadline, but for instance, if you've got, after you've filed your pleadings, whether it's a ticket or whether it's an information, you'll get a date of first appearance. And that date's basically for everything to come together. Sometimes it's before a JJP. Rarely it's before a judge, but sometimes it can be. And it's like a triage court. Okay, what's on the docket? Okay, this. Oh, okay, I got charged with this. Okay, what are we doing here? How are you going to plead, right? So they could plea out uh, for sentencing, or in most cases, it's not guilty and it's going to get set for a hearing date. Now, I always say get the disclosure done sooner because you'll save time and not have to do a second hearing if they haven't got the disclosure, right? Because a lot of people are going to say, oh, I don't know what the case is about. Well, if they didn't have disclosure, then it's going to get adjourned to another date, which is another month away, right? So I'd get the disclosure out as soon as you can and before the first appearance date. That's the short answer. Okay. We've got one here, and a JJP address as your worship, judge as your honor.
That's correct. It's a JJP is your worship and a judge is your honor.
There you go. That is the answer to that one. How much practice or rehearsing is appropriate to do before testing without sounding scripted? Great question. We don't want to sound scripted. So the reality that I say to people is have a template of questions and answers and know kind of where it's coming from so you can actually understand that, but you don't take that into court. Then you have to then speak extemporaneously. I can't believe I said that word in one first try. That was multi-syllable. That's really good for me. And then you can then look like it's more authentic, right? You don't want to look scripted. And you always have to remember to think about the question you're getting.
We tell our junior lawyers that when you are practicing rehearsing, that you do it out loud. Don't just think that what you're reading on a screen is going to translate into an oral answer. It's a good practice to actually say these things out loud. Close your door. Maybe one of your friends can be the litigant that's going to be cross-examining you. Pull somebody in there so they can throw you some wild cards, and so you'll be ready. And there's not too much. I would say at least 3 times.
Okay, Rose has got a great question. How do you stop the sweat in your upper lip when you're testifying or your voice cracking? Tissue, upper lip sweat, great for that. Okay.
I think the
And
judges understand that this isn't your usual position. As long as you're coming across as authentic, I don't think
yeah,
they'll be upset if you're sweating a little.
yeah, and then the other thing too is that you can always preface it and tell the judge, this is my first time, or, I've not done this very often, that kind of stuff. And then there'll be a little more sympathy given to you. But one thing to keep in mind is that you're still professional staff. And if you've got lay witnesses, you can't look kind of too weak before them, right? So you want to build their confidence because they need it more than you need it. And by the way, we do have a trick for this. Most of our trial type hearings, if we just have one professional staff, usually who's sort of the instructing client and guides the show for us, gives us our instructions, um, we put that witness on last, right? So you get this benefit when we do a prosecution that nobody else gets, which is you can listen to all the evidence, sit in the courtroom, be right behind us, watch the Broadway show, know exactly what everyone's saying, and get comfortable in that role. And then you're going to be our last witness. It's beautiful, right? And believe me, the other side hates that stuff, and they don't get that same benefit, right? So, especially with their spouses, I love it. I love splitting spouses. Like, no, I appreciate that's your spouse, but Mrs. So and so has to get out of the courtroom, and that totally throws them off. Well, how come you let DeSouza witness? That's just the bylaw officer that's harassing me. Oh yeah, well that's his instructing client. I'm sorry. You know, so those are the things that are going to be helpful for you. Um,
There's a question from Danielle Nolan, was asking questions back to the person that was asking questions to ask if the question was relevant. So he started asking questions that didn't apply to the charges before us. Was it okay that I questioned why I was being questioned on the topic instead of answering? And Danielle Nolan is asking you to remember the time you were in Kelowna with them. Okay, I'll just pop in and say, usually if you have a lawyer there with you, they're going to object to questions that seem questionable. That wouldn't be your job. But sure, I think if you're there by yourself, you can ask the judge if this is a question that you need to answer.
yeah, and what I would add to what Kismet said is I would give them a couple of times to ask irrelevant questions before you ask the judge that, right? So give them a bit of rope because even the judges will get like, what's the relevance? But yeah, here's the thing. And Daniel, that's a great question, and I remember that trial too. Um, the other side, you want them to kind of look bad a bit, and if they have to badger you a bit, so be it. If they're going to make themselves look bad. On the same side, we have expertise as legal counsel, so we can't come off like too strong, like we're bullying people to shut them up or something, right? So we can't say objection, objection. It sounds great in TV, but it doesn't work in practice. So we have to let them ride a bit. So I usually allow them to ride for at least 3 to 5 idiotic questions before I step up and say, you judge, there's been a whole list of questions here that we've let go, but we think we should focus on relevancy and stuff like that, right? And say it in a nice way that gives the judge the ability to say, yeah, yeah, I think that's good. So that's the best thing. And if there's no counseling, you're on the stand because it's your ticket, Danielle, then I'd let them ask a couple of idiotic questions and then look to the judge. Judge, I'm not sure what the relevance is, but I'm happy to answer the question as best as I can if the court permits it. And then that's a trigger to the judge to say, yeah, I'm not sure if we should be listening to this because remember, court time is limited. And it's not just our case, there's other cases that have to be heard. And the judge has got a big docket to clear out. So utilize the time of the court is very useful, but also making the other side look like stupid is also useful too.
There's
Okay,
another
good.
question from Colin Ash of Saanich. Do courts want a pretrial conference for prosecution of an MTI?
Good question. They don't need it. It's not for an MTI. They should need it. Pre-trials are in fact things that are optional at the Supreme Court level, and they could be used in some form of application at provincial court if there's some issues we got to hash out. But for a ticket, one count, you know what, Colin? It's got to be a pretty complex or important MTI to have that. If you anticipate problems, right? The it's possible you can make an application to court for some what we call direction from the court over the hearing, but it'd be very unusual. I'd suggest contact your legal counsel first to see if that's worthwhile doing before you go through all that work to do that.
There's a question from Mark at the CRD. If you are dealing with a tree cutting bylaw and you decide to call an arborist as a witness, is it a good idea to have the arborist prepare a CV before trial?
Great question, Mark. And it's absolutely a necessary idea to have that CV. In fact, if you're calling an arborist, you're not calling Joe the tree cutter, right? And I know Joe, he's a good friend of mine. You're calling a professional who knows something and they've gone through schooling and all that stuff for that purpose. So not only do they have to show their CV, but they should also have a very brief expert report. It can be as short as one page. What exactly are they saying about the tree that you're obviously looking at perhaps unlawful tree cutting or something like that or something, right? So that's they're a professional, they're an expert. If they're your witness, you're calling them a one-page report, which of course will have to be disclosed at the earliest opportunity. Okay. Hope that makes sense. But yeah, there are some professions that are they don't give testimony like a Joe. I mean, I guess you could call an arborist as did you see a tree cut? But that's, anyone could do that. But I think what you're trying to get at is they have some expertise and you might as well use their expertise um, for that purpose. Now, of course, and try to read the between the lines here, Mark. If it's on the other side and they're calling an arborist, well, demand their CV, demand their report. What the hell are they going to say? You can't just bring an expert on without seeing and knowing what they're going to say, right? Because you may decide, Mark, that you need your own arborist. So that's the other corollary side to that is who's calling the arborist and for what purpose.
And the judge will typically try to qualify that person as an expert, and so they can ground their decision. There's a question from bylaw external. I don't know which bylaw external that is. Can we bring notes to refer to when being a witness?
Yeah, before I get that, I just want to answer Rosa's question. Rosa, I know you. You're extremely confident. You're just trolling me on being nervous because I know you. You're super confident. You're awesome. Um, yeah, take deep breaths is all good. Sorry. Can you bring notes to refer being a witness? The answer is yes, but do not show them in court unless you ask permission for the judge. So your notes are there in a closed folder or whatever you have, and you're being asked questions. And we get this a lot. You're not going to remember all the dates. You're not going to remember specific things, but your notes are there, and you can tell the judge, Judge, I don't recall this. May I refer to my notes, which, by the way, should have been disclosed to the other side anyway, right? And you can tell the court all of this has been disclosed already, but I just need to refresh my notes because remember one of the things I said in terms of the best evidence stuff, right? While we do take witness statements or some things we have our notes, we don't use witness statements, right? We can use notes as business records. We can sometimes put it in if there's a value to that. If not, I wouldn't put it in. But there is a refreshing value to refresh yourself with the evidence. Bring your notes, don't show it, ask the judge, and then the judge will let you read the notes.
The provincial court judges are more and more inclined to receive a summary from litigants. At least that's what they were telling the lawyers. So I imagine it would be, if the bylaw officer came prepared like that, they'd be happy to receive it. But if you do prepare anything, make sure you have 4 copies of it so that you have one to give to the other side and let them know that you're going to be presenting this before before you go up. And what it could be is like a chronology. And so it's easy for the court to follow along, but always make sure you disclose it, have a copy to disclose to the other side. There's a question from Rob Harris. Is there a way to keep your witnesses apart or isolated from defense witnesses when outside the courtroom waiting to give testimony?
Yes, tell them to sit over there as opposed to over here. They shouldn't be commingling, right? So, great question, Rob, but just your witnesses are you are responsible. You can control them. You could say, sit apart here so you guys don't discuss the testimony. Because clearly there's two sides on a court case, right? So generally, practically, they're not sitting together like a bunch of chums anyway. But you definitely want to keep them apart. And just, I want to answer, there's a note above, if you're not sweating on the witness stand, you might be considered too cold. On the other side, if you're sweating too much, you might be considered a liar. So there's a fine balance. Minimize the sweat. Use the tissue. Okay. Keep it clean. Okie
Um,
dokie.
there's a
Um,
question from Rob again. Can you provide an email from an expert witness as an exhibit without the expert there? A provincial representative providing an explanation on provincial legislation?
so I'll come back to Roger. I see something from my good buddy Ian Fraser from VAX. The Victoria Court Registry requires a PTC for all disputed MTIs. Well, that's interesting to know. Um,
Mhm.
so 2 points of that. Every registry is like its own fiefdom, right? They can have their own sort of rules and procedures that aren't, frankly, statutorily set up. If you want to play the legal game here and say, should there even be an appearance, a first appearance for an MTI, which happens now in all the registries? I'll tell you no. If you look at the statute under the community charter, which sets the scheme for MTIs, all that's required once you file a dispute is the court sends out a notice of hearing in ordinary mail, right? So there shouldn't be any of that. But the courts have basically, because it's in the criminal registry, are wanting to teach you how to suck eggs. So they're trying to control that process. So if Victoria Registry is doing a pretrial conference for MTIs, well, that's what they're doing. So follow along with that and play the game. Hopefully, it's not too much of an inconvenience of your time, but I'm sure there's a reason for that, and there's also a reason that you shouldn't have to do that. John, thanks for being there. Good to see you. Okay, so Rob, can you provide an email from an expert witness as an exhibit without the expert there? A provincial court representative providing an explanation. Okay, that's a good one,
Generally,
Rob.
pieces of paper without people who wrote the pieces of paper are not worth the piece of paper that they're written on.
Yeah,
So depending on, I'm just trying to read between the lines that you have there, Rob. If you're going to be putting something on a piece of paper, the person that wrote the piece of paper needs to be there.
yes. I mean, otherwise, it's what we call hearsay, and it's not going to be allowed in a typical trial, certainly in provincial court. Interestingly enough, though, I believe one of our lawyers, Zach Curry, I'm going to name names, put with our clients' approval, of course, a letter they got from another agency talking about the legislative process or something like that in our client's affidavit. It was just a letter because we're not going to get an affidavit from that other agency. And the court did make note of that. The court said, "Hey, look, that is hearsay, but it was there to prove the point that look, this is going to be a complicated process that the local government didn't want to have to undertake. So we didn't use it for the proof of the facts of the matter, but it was very helpful for the court, frankly, to see what another agency would say. So it's kind of like a little tongue in cheek. We if it's helpful for us, we're going to try to get away with it, but we could get caught. The biggest thing, Rob, is make sure that the expert witness or whatever you're trying to use there, the evidence does not meet a key element of your offense, right? So that's the key. If it's gonna undermine that because you don't have that report or it's not in properly, you can lose the case. So it's just if it's what I call a little bit of icing on the cake, yeah, throw it in. Have some fun with that. But if it's fundamental to the cake and the foundation, it's an egg or the flour or the sugar, whatever you got to do in it, then keep it out or get the evidence correctly. Okay. Great question, Colin, from unreasonable delay in bringing a matter to trial, the Jordan delay. Well, great question. 18 months. Remember that date. 18 months is when you have from the moment you start proceedings to when it has to be heard in court. Okay. So there's a clock running and you got to move on it as quickly as you can. And there are going to be some adjournments. Most matters should be able to get done within that time. But if the adjournments are going to be made, preferably, this is what you got to do. It's a bit of a game. You get the defense to say, yes, I need an adjournment, even if it means that you're not quite ready or something, right? Or if you need the adjournment, get the defense to say it. So then that 18 months and the extra time that it gets to hearing is a defense adjournment, so it doesn't count. So you can sort of subtract from that, right? And that's all a mathematical formula. So we've dealt with actually a couple of cases where uh, parties tried to get our case dismissed based on the Jordan rule, but they were unsuccessful. And it is a bit of a painful process doing the math in that. So you're doing, well, who adjourned for what reason here, and who did this, and who did that. And then we basically work out the math, and it's really a kind of a close to mathematical formula, and the court will make a decision based on that. So good question, but remember, always try to get the other side to seek the adjournment, and then you won't get in trouble with Jordan. Okie dokie. I think that is good. We've gone a bit beyond our time. We've had some great questions here. I want to thank all of you for joining us here today. Thank you for everybody for participating. And we'll hopefully see you at the next webinar on Thursday, September 25 on the case law update, but funner. And with that, I wish you a wonderful rest of your day and upcoming weekend. Live long and prosper. Take care all.
Bye, everyone.